I'm going to start by laying out, and this may seem a little pretentious of me, but 4 essential truths. That sounds good, doesn't it? That I think are constantly overlooked and certainly pushed aside amidst all of the debate and discussions, this tumultuous relationship that exists between human rights and security. I think we're going to be doing that a lot tonight, human rights and security. The first is this, and it's an important one for us in the human rights community to keep reminding ourselves. Acts of terrorism are human rights violations. And they are of very serious concern from a human rights perspective. It's not that terrorism is not a worry for the human rights community. In fact, very often, terrorist attacks constitute human rights violations of the very highest order within the international legal system, within international human rights law, crimes against humanity. And that means that governments are not only permitted, the human rights community won't just sit back begrudgingly and allow governments, accept the fact that governments may do something to deal with terrorism. Far beyond that, governments have a binding and clear human rights obligation to do something about acts of terrorism. And I'll begin by saying to you, time after time in countries all around the world, Amnesty has, in our actions and our reports and our documenting, taken governments to task for a complete and utter failure to do so, to not respond, to not give a damn, to not care, and thus violate their human rights obligations. And far too many governments continue to stick to the dangerous, discredited assertion, and here I'm going to do this again, that human rights and security are somehow a zero-sum game. You want more of one, you got to give up on the other. More human rights, sorry, you're going to be more insecure. You really want to be secure? I hope you're going to accept the fact that your human rights are going to be more imperiled. And that, of course, could not be further from the truth. Because we do not face, who could possibly believe that we face terrorism and other insecurity? Because we've gone wild in protecting human rights. And we're out of control in delivering justice around the world. I'm not sensing any agreement with that proposition, and of course, it's absolutely the contrary. Insecurity so frequently goes hand in hand, at best, with human rights neglect, and at worst, and far too often, human rights contempt. So if we are truly serious about wanting security, and we are from a human rights perspective, it's important, about wanting to feel safe, that must mean security and safety, and here's the key words, for all of us. And that means, far from continuing to distance ourselves from the precious promises of universal human rights protection, it's the universal Declaration of Human Rights, embracing those rights to life, to be free from torture, to be protected from discrimination, to free expression and religion, to due process and fair trials, to education, to health care, to adequate housing. Embracing those rights like never before is absolutely the path we need to embark on. A second, though, is that obviously efforts to both prevent and respond to terrorism must at all times comply with the requirements of international human rights law and international humanitarian law. They're not separate and apart somehow. And that includes a whole variety of rights. It includes all rights, but as we know, as we've seen this play out in countries around the world, and as we've been through the debates and the cases in our own country, we know that there are particular rights that are almost always engaged, and they're important rights. It's the right to life. It's the prohibition on torture and ill treatment, the ban on discrimination. It's safeguards against arbitrary arrest and unlawful detention, fair trial guarantees, and the freedoms of expression, of association, of assembly, and religion. International law anticipates this. It anticipates insecurity. It anticipates acts that governments will have to respond to in order to keep their populations safe. And as such, lays out in the international human rights system, carefully drafted, very specifically circumscribed reasons and situations in which it is possible to, in a very limited context, temporarily, as needed, constrain or violate, limit some, not all, rights. There are others, however, and this is governments that did this. This wasn't Amnesty International way back then, writing this down and coming up with these limits. There are other rights that governments, as they crafted the treaties, knew could never bear any exception. And that, of course, very much relevant to our debates around national security, includes the ironclad, unconditional, no exceptions, applies to everyone, ban on torture. A legal principle that has, I suppose to say the least, been sorely tested in recent years. But here is essential truth number 2. When it comes to national security, when it comes to counterterrorism, governments must comply with the human rights norms they established. Third, ensuring that national security is grounded in full regard for human rights is not just a human rights imperative. It is also essential from a national security perspective. Legislating, ordering, allowing, or taking advantage of human rights violations in the name of security betrays that very goal of security, because it only creates more victims, more marginalized communities, more grievances, greater divisions, all of which serve in the end to do what? Foment insecurity. Subject a family, a community, a village, a faith group, a people to unrelenting and capricious discrimination, arbitrary detention, and torture, and we somehow imagine that opens up a magical path to understanding, reconciliation, and coexistence? Of course not. And here's the fourth that I want to begin with, and that is that it's absolutely crucial to keep in mind that worldwide national security has been used regularly. I could easily give you a pile of Amnesty reports this high as an excuse, a pretext, a cover, a shield, a justification, a defense for human rights violations by governments of all political stripes for a host of different motives. National security in name, but the real game, something else. Cracking down on political opponents, crushing followers of a particular religion, targeting a minority, or more often than not, simply greedily and crassly seeking to hold on to power. National security is used to explain why the impact of laws disproportionately, unfortunately, impact on one group, one religion. National security is put out there as the reason. It's okay, shrug shoulders and say, yes, the fallout is too bad, but what are we to do? A bit of sense of powerlessness. But the point here is, and I think it's a very important one, just because governments say it is about national security does not somehow magically and automatically make it so. We need to talk about the Anti-Terrorism Act 2015. And to put it very baldly and simply, what we have is a response to concerns about security that takes us further away from human rights than any other national security reforms we have ever seen in Canada. Ever. The human rights failings are in fact so numerous and so serious that over the few short months, I'll come back to that Bill C-51 was moving through the parliamentary process, Amnesty said, and we actually very rarely say this around legislation, that it was beyond redemption. It was beyond saving. We usually get in there and roll up our sleeves and we say, okay, on page 2, paragraph 3, if you took out that line and you added this, let's move to page 6, page 9. We said it was pointless. There was so much that was wrong with this bill, and it was all so deeply interconnected that we said that the only defensible way forward was to withdraw it and start again. Those concerns begin with the fundamental question that any government must be able to answer with any new law, and that's especially true with a law that trumps all over our rights. And the question is this: why? Why is it needed? What's the rationale? What's the purpose? That question was asked repeatedly. I bet you many of you asked it, maybe even when you had a chance to engage with your MP or in other fora. And if any of you got an answer to it, you are heroic, because it was a question that was never answered. What is missing in what we've got now? What are the gaps? What is the problem with the existing laws? And how is that separate and apart from perhaps how the laws are enforced, or how the officials are trained, or how the financial, human, and logistical resources are determined and deployed? Even now, it still defies my belief, but it's true, that, for instance, the government refused to allow Canada's Privacy Commissioner to appear before the House of Commons committee that was studying that bill. A piece of legislation that has assaulted privacy rights in this country perhaps more than anything else in decades. And parliamentarians weren't allowed to hear from the Privacy Commissioner is an officer of Parliament. He doesn't belong to the government. They were not allowed to hear from that expert. If you expressed concern, if you were the skeptical inquisitor, if you were standing up for human rights in any way, shut right down, because you were siding with the terrorists. And we could not move the quality and the nature of the parliamentary debate beyond that. The first is the expansive definitions of threats to the security of Canada that now serve as the basis of two new regimes in this legislation. One is a new, incredibly expansive information sharing regime, and the other is astounding new powers that have been given to CSIS, which up to this point in time has been a research organization. Gather intelligence, analyze it, and report to government, but is now allowed to act and is given specific powers to act to reduce threats. Concern number two, let's think in particular about those new powers, the CSIS threat reduction powers. And this, friends, is astounding. We have never seen anything like this before in Canadian law. These potentially coercive, intrusive, and physical powers, this isn't just about CSIS agents sitting at their desks and doing things on the computer, are now entrusted to an agency that, let's not forget, is not a law enforcement force, doesn't have any of that specific training or command structures or the public transparency, which often fails us, but is at least demanded and expected of police forces. Secondly, the powers are not specified. We don't know what it is that CSIS might be contemplating and might be willing and allowed to do to reduce threats. We have absolutely no idea of what is entailed. But here's the real rub. This legislation actually does go on, I guess this is our little clue, it does go on to tell us, though, what is not allowed. And we actually have a piece of legislation now in Canada that says CSIS cannot murder, rape, beat people up, and lie to judges. They use more sort of criminal code terms for all of that, but that's actually what it says. So we can all go, phew, but just kind of sit with that for a minute. Wow, it was necessary to write that down. That's kind of the first thing that comes to mind. Wow, you mean that was possibly part and parcel of what might have been the powers that CSIS was going to exercise? So we get this glimpse, but boy, does that glimpse give you a shudder as to what may be at stake here. But then thirdly, from a human rights perspective, wow, there's a whole long list of your human rights that are not there. Very notably, given the circumstances in which we know these powers would likely be exercised, there's nothing there at all around any of the liberty and due process rights. There's nothing there to protect us from arbitrary arrest, detention, abduction, kidnapping, nothing that would require that if we were arbitrarily arrested, illegally kidnapped, that we would at least be brought in front of a judge and have all of our due process rights and the right to be charged. None of that is there. Absolutely nothing. We do have the can't beat you up piece, so that takes us partway down the torture road. But in the national security world, when torture comes up, we know, years and years of documenting it now, that right alongside the physical beatings, it's the psychological and mental torment, those forms of torture that are so regularly used. That's not on the list. None of the freedoms are there. Freedom of expression, freedom of association, freedom of assembly, freedom of religion. Nothing there about discrimination. But don't worry, you will not be murdered, raped, or beaten up by a CSIS agent, and if they did do any of those things, they won't lie about it to a judge. But what about judges then? And the other thing that is chilling about this particular part of the legislation, friends, is that the bill actually, the law, does actually go on to contemplate the fact that, some of these things might violate the Charter, these undefined things beyond the 4 prohibited categories. From a human rights perspective, I'm reading along and I'm kind of hoping naively then that the next words will be, therefore, if this would violate the Charter, dear CSIS agent, I guess legislation doesn't say dear CSIS agent, don't do it. No way. It says, if this might violate the Charter, dear CSIS agent, go to a judge. Okay? Well, then we assume that the next words will be, and dear judge, if CSIS agent has come in front of you with something that would violate the Charter, don't authorize it. It doesn't say that. It says to the judge, when CSIS comes in front of you with one of these applications for an authorization for a warrant, a charter-violating warrant. Imagine that. Well, you're supposed to balance things. Here's some of the things you should take into account. And oh, by the way, do not have regard for any other law. You're not allowed to pay attention to any other laws. And furthermore, just to be specific, because CSIS will often be doing this outside of Canada, that also includes you are not allowed to have any regard for foreign law in the countries where CSIS may be doing this. So if CSIS is going to arbitrarily arrest, abduct someone in Malaysia or Sweden or South Africa, don't you dare pay any attention to the laws in those countries that may say, guess what? Arbitrarily arresting, kidnapping, abducting, mental and psychological torture is illegal. I mean, it's stunning on every level imaginable. Obviously, from a human rights perspective, it couldn't be more offensive that we have legislation that is both contemplating and authorizing human rights violations. It's also from the state of our nation, from the notion of what governance and democracy is all about, is so corrosive because we had legislators who felt, and obviously there were many who voted against it, but not all, who felt it was absolutely fine to vote for a piece of legislation that draws judges into violating rights. Remember that thing called separation of powers? Aren't judges the ones who are supposed to be the guardians to ensure that doesn't happen? Sure, what I studied in law school, I was in law school as the Charter of Rights had just been adopted, and we were celebrating this incredible new role that the judiciary was going to play in Canada. And here we are in 2015 with a piece of legislation like that. I believe in judges. And even conservative-minded judges, I am confident, will be so offended by this that when it does come in front of a judge, there is going to be a ruling that says, and we'll be there, we'll be looking for ways to get involved in court to make sure this happens, that says, Asking me to authorize violations of the Charter violates the Charter, and strike it down. But we're not there yet, and it already is the law. For all we know, this afternoon, CSIS was in a courtroom in Vancouver or Toronto or Ottawa, getting one of these warrants that may target any of you, or that may authorize some action of this sort in any corner of the world, and we will not know because it's secretive. There's no transparency around any of this. So boy, is that an area we need to be concerned about. We also have a very troubling expansion of detention powers in Bill C-51. Detention powers in itself isn't bad, but these are detention powers without charge. Being held in detention without charge. It's a legal tool known as recognizance with conditions. But this is of real concern because liberty rights matter. They matter a lot. Freedom is one of those other things that's at the very core of what it is to have rights. You know, without your freedom, all of the other rights matter not, do they? And they therefore must be scrupulously protected. And most essentially, that means by ensuring that arrest is on the basis of intent. It doesn't need to happen within 15 minutes, but with intent to promptly lay a recognized criminal charge, and that the ongoing detention after that charge is only in furtherance of getting quickly to a prompt and fair trial. That's what it's all about. That's the essential framework of how the international human rights system understands liberty. Well, now we're reducing the threshold of suspicion for an arrest without charge from an assertion that we have to do it because we think that person will carry out some sort of terrorist act, to now that the assessment is simply needed because it may be carried out. There's a sea of difference legally between will and may. And then beyond that, it increases the potential length of arrest. From right now in Canadian law, the possibility of being held without charge for 3 days to now being held without charge for 7 days. The UN Human Rights Committee has said that this sort of security detention should be used only to address a present, direct, and imperative threat which cannot be addressed through any other alternative measures. I don't think we're quite in line with the UN's advice here. I mean, we agree that information sharing is both inevitable but even necessary in dealing with security threats. Of course it is. Of course it is. You know, silos and sitting on information and not letting one agency speak to another or even one government speak to another is not going to do any of us any favors in dealing with security issues. It's also helpful from a human rights perspective to make sure that information gets shared, including, for instance, when we're wanting governments to do everything they can to find and hold human rights violators to account for their crimes. But it also has such clear potential to violate human rights, most obviously privacy rights, but we also know that sharing information that has been inaccurate and irrelevant and unfounded and inflammatory, and it often is, goes far beyond intruding on our privacy, and it has frequently led to very serious human rights violations, including to the extremes of torture. That has been documented, for instance, in 2 judicial inquiries in Canada, not just in Amnesty International reports. That's the story of Meher Arar. Remember his case? Most of you will. That was a judicial inquiry. Was it the story of 3 other Canadian men, Abdullah El-Malki, Ahmed El-Mati, and Mouiad Nuruddin? Another judicial inquiry. And information sharing, inflammatory, inaccurate, unfounded, unjustified, unsubstantiated information sharing is what set the whole chain of events into motion that at the end of the day saw those 4 men tortured in Syria and in Ahmed El-Mati's case also in Egypt. So that means that the permissible reasons for sharing information widely must be tightly and carefully limited. The stunningly vast list we see in C-51, as I say, with terrorism only at number 4 on the list, is anything but that. There's concerns about the no-fly list. I'm sure many of you have followed this, and in particular the fact that the appeal procedure that is set up to try to get your name off that list. And we know, I'm sure many of you have friends and colleagues who have experiences and stories to share. We know that there are so many erroneous ways in which people end up on the list. And it's a completely unfair, opaque, secretive process that will, it's an illusion that it actually offers you a way to get off the list. And this bill, I won't, I think I got to cut some of this short a bit. This bill also deepens the unfairness and the injustices that are at the heart of our immigration security certificate process. It brings a new level of secrecy. It withholds further information from the individuals who are subjected to immigration security certificates. Well, the problems about C-51, as I say, are not only, though, about what is in the bill, it's also about what is not in the bill. Notably, we have nothing in place at all with respect to parliamentary oversight. We don't give our elected representatives power to oversee the agencies that are entrusted with our national security. Agencies that also, in upholding that national security, have the power and have done so to violate our rights. But our elected representatives have no oversight of them. So there's problems with what's in the bill, there's problems with what's not in the bill, and there's the bigger concern that we're still not where we need to be in cementing our commitment to national security in Canada truly in an international human rights framework. We need to continue to insist that the bill be repealed. These legal reforms, I would put to you, are instead all about insecurity. And what I mean by that is the insecurity of human rights. And when human rights are left insecure, we are all insecure. And that's why we have to continue to insist more broadly, beyond Bill C-51. Even if Bill C-51 gets repealed and we're back into some other exercise of law reform, that national security laws and policies and activities in this country must have human rights at their very core. That's what the struggle about Bill C-51 certainly always has been about and still is. And that, my friends, is what true and meaningful and lasting and universal security is all about at the very end. Thank you very much.